The CPI report, Child Protection in Iowa, brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 in Greater Des Moines on Sunday afternoon at 1 o'clock, and again it's repeated Wednesday evening at 9:30. This program also airs in Council Bluffs on Cox Channel 23 every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. My number is area code 515-276-3956. John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa, and one of our issues is to influence public policy that surrounding the child protection system in Iowa. If it has something to do with protecting children, that's something we want to talk about. Not only do we do the influencing of public policy, but we also roll up our sleeves and work directly with families who need assistance, who may be having difficulties with the Department of Human Services and the juvenile court. Now, we are not attorneys, so we do not hold ourselves out to do legal work or to represent you before the bar, but we've talked to enough clients and we've had enough personal experience with the department that we think we can offer some valuable hints to you in your struggle to keep your family together and to keep your family isolated from the Department of Human Services and their large claws. Well, the Iowa State General Assembly has assembled. Their work right now is primarily in appropriations. And doing the appropriations, they want to simply make sure that money's made available primarily for the schools and then available for other things as well. That opens up the way then for them to turn a whole lot more attention later on to the legislative things. And by the way, I feel some compassion for these legislators that have to look through literally thousands of bills, and the bills quite often, as you read them, don't make a whole lot of sense. In other words, you can have a bill that's a paragraph long. Doesn't take long to read it. By the time you research all of the references to which it made, and then you read the explanation for the bill, you have some wonder as to what that bill is all about, what it actually does. So when you have 1,500 of those on your desk, it is rather a panic. I talked to one new senator who came in on this past year, and he says it's like a zoo down there. And he said he had, as a subcommittee meeting, something like 20 bills that he had to go through personally and check out to determine whether or not it would pass the subcommittee. So he has to dig in. And I think primarily a lot of the decision making in our General Assembly is kind of like word of the mouth, you know. Are you going to vote for this bill? Are you going to vote for this bill? And then, of course, there are something called lobbyists. In the case of the Department of Human Services, I remember one state representative said that he was so disgusted because there was something like, it's either 32 or 35 lobbyists for the Department of Human Services. And of course, these are paid lobbyists who make money somehow or another from the Department of Human Services. And so they're only interested in getting those bills passed, which will help to inflate the income of the people that they represent, that is, the lobbyists represent. So it is a real zoo, as Senator Brad Zahn um, uh, named it uh, down there, and he didn't feel comfortable last year. I haven't talked to him this year. Perhaps we should talk to Senator Zahn from Urbandale and see if he would like to share some of his zoo stories, and just how lucky he may be in getting certain things passed or fostering certain kinds of changes to the law. You know, with the number of bills that I've seen, it appears as though many of those bills have nothing to do with enhancing our livelihood, enhancing our quality of life. I have almost come to the conclusion that there ought to be a bill which says writing bills is prohibited. That way we wouldn't have to have all these tinkerers fiddle-fooling around with the statutes. The one agency that does the most tinkering with the statute is the Department of Human Services. So you'll find a number of bills chalked up to their account. They seem to want to change this and change that. It's difficult for any person who concentrates on the Department of Human Services rules and regulations to keep track of what is actually going on. Sometimes I get behind in what they're actually attempting to accomplish. And we can show you a couple of those, I think, if we have time on today's program. One of the things that we've been talking about pretty strongly on this program is something called the 2,000-foot rule. And you may have caught a hint as to my feelings, my position on the 2,000-foot rule. It's simply this, that we should back up, turn around, recognize that in 2002 we passed a very poor bill. In 2005 we enhanced that bill, and at the cost of $5.5 million per year, rising in 4 years to $12 million, so that we can get so-called tough on crime. You see, getting tough on crime may be thought of as a ticket for re-election. Getting tough on crime may get you all kinds of accolades in your hometown. But I'm not sure that it's the right thing to do for the people of Iowa to keep talking about getting tough on crime, doubling the penalties for this. And doubling the penalties does what? Well, for a person with an estimated cost of $70,000 a year to keep him in prison, doubling the cost, or doubling the time that he spends in prison, simply means another $700,000 that's going to cost taxpayers. I think that when we get a bill like that, we need to stop and consider, is this what we really want? Does it produce the result that we wish? I think in many times we stop and grab onto something, say, oh, we got to get tough on crime. There needs to be zero tolerance on this kind of behavior, and that might well be. But when we double the penalties, when we put on ankle bracelets, when we do all kinds of silly things like the 2,000-foot rule, that simply keeps our police from doing the jobs for which they were hired. Running after probation violators, checking to see if the apartment is 2,000 feet or 1,983 feet from a school. In one case, I understood that it was just a few feet difference, and they were willing to lock up a man for that few foot difference. The law was crazy in the first place. So now we're having police go out and check each place. And in one of the articles that we have on today's program, we find out that we can't even keep track of over 300 of those people. Now, couldn't one of those 300 be a dangerous person? Um, and we can't even keep track of that. Well, we've taken on a monumental task. It is not a royal thing to consider having people first of all, whom we do not like to have around us. It is not a glorious thing to contemplate to having people whose behavior is not what we would consider to be appropriate living in our communities. But what would happen if we decided that all people that we disagree with, or all people whose behavior is not what we would like lazy people, alcoholics, any kind of behavior that we disagree with, or which could be, as in the case of alcoholics, could be detrimental in a domestic situation, or could certainly be detrimental on the highways. Can we consider making laws which would micromanage those families, simply ostracize them? Well, if we start with the 2,000-foot rule, we are setting a very bad precedent.
So let me ask this, John. I hate to interrupt you. So
Sure.
you're saying that they could down the line issue a law that says, well, all people that have been convicted of drunk driving, they have to live 200 feet away from a car.
Correct.
Or I mean, that's stretching it to one point of insanity. But say all guys who have had a domestic assault conviction can't live with a woman. Things of that sort of nature.
Right.
And they have to be 100 feet away from a woman.
Well, that's precisely.
I think I see your point. That's a pretty good point, though.
That's precisely the hazards of what they call this slippery slope, because once you create the precedent, then anything would be possible. And I created a couple of silly ones, on the program last time. I said, what if we decided we didn't like Presbyterians, and we decided that no Presbyterians shall live in Windsor Heights? What if we didn't like the behavior of the black people that we knew, and said the black people cannot live in Pleasant Hill? Well, that's not discriminatory, because there's other places where they could live. We could argue. We just don't want them in Pleasant Hill. Well, I'm not sure that would go over real big. But if you plant a precedent, then you are in real trouble. That is, what you're saying is, we're going to make public policy with a 2,000-foot rule, which could be very slippery. And we're going to find that prosecutors and other people, while they're probably at the root of some of these problems that we're seeing right now, they don't want to deal with a 2,000-foot rule. A gentleman who serves in the state General Assembly comes from Marshall County. In fact, he comes from Marshalltown. His name is Larry McKibben. And by the way, you can write to most of these people in the state General Assembly by simply putting a dot between their first name and their last name, and then adding the at legis dot state dot ia dot us, and that'll get you to Larry McKibben's desk, or to any other assemblyman that you want to speak to or to write to. Keep the notes short, keep them to the point, and tell them that you are in their congressional district, in the area in which they represent. In some cases, you may want to write to committee chairman, and it's perfectly all right to write to committee chairman, because those people will have plenty of authority to do the kinds of things that need to be done in order to clear out some of these problems. Before I forget, I wanted to make one other comment. Not only should we turn around in this project of the 2,000-foot rule and seek far better remedies to the disaster that we've seen, but we need to compensate those individuals who, since 2002, have had to consider other alternatives. Right now, it is a major disaster. Something close to Katrina type disaster, to tell somebody that they have to pick up and find quarters somewhere else. When they have a family at home and the costs take the paychecks of both mom and father, how in the world do they find funds to live someplace else? And how in the world do they manage to get another vehicle to get back and forth to work? I just do not see how that can be done. And I think the state legislature should simply say, hey, we're going to cut, like we did for Katrina, we're going to cut a $2,000 check for each one of you who have been tapped on the shoulder and told by the police to move over, to move somewhere else. So I think that unless the individual can show that their damages are greater than $2,000, I think we ought to cut them a minimum check of saying, sorry about that, we're going to try to make it right with you with a mere $2,000. I think that it would be good for the state legislators to say, look, we know when we made a mistake, and we're willing not only to turn around, but we're willing to compensate those people for the damages that were caused by this error. That's a big request, isn't it? But I think that that it behooves us to make things right with these individuals who have been wronged. We recognize wrong when we filed suit against these people, people that are on the registry. We knew it was wrong, and that's why they were punished. That's why they served their time. We ought to also recognize that these people have a right to go back into society, and they need our assistance and not our banishment. Larry McKibben has a different way of thinking about the 2,000-foot rule. Many Iowans were shocked by recent views of Vermont Judge Edward Cashman's decision to sentence a man to only 60 days in jail for repeatedly raping a 6-year-old girl. See, we shouldn't even consider that because that's not a part of Iowa law. Why should we be terribly upset about that? That's Vermont law. Okay, since the ruling, thousands of calls have poured in to the Vermont State House, and people are outraged, and rightly so, that the needs of innocent children have taken a back seat to those of sexual predators. This article comes from the Des Moines Register. We need to give, we need to attribute these words to the Des Moines Register in an article written by
Larry McKibben.
No, it wasn't written by Larry McKibben. Oh, yeah, it was written by him, and it was published January the 23rd.
I think it'd be a good idea to give him the credit, John.
For writing the story?
Sure.
Okay.
Since his name is on it.
You bet. Okay. So this must have been an opinion on the opinion page or something. Well, the first purpose of government is protecting public safety. As government officials, state lawmakers have a responsibility to ensure safe neighborhoods and communities for children and their families. It was with this responsibility in mind that the Iowa legislature approved a 2002 law requiring certain sex offenders to live at least 2,000 feet away from schools and child care centers. By the way, you know what a child care center really is? It's called a family. So you'd have to live 2,000 feet away from a family if you wanted to really stick to the law, wouldn't you? Well, such laws have been adopted in at least 14 states. Is that a reason why we should adopt a law? Because 14 other states have made a goofy decision? And more are considering the issue every day. Enforcement of the law is not always easy. However, the existence of these restrictions sends a message to Iowa families that this state is concerned about safety of its youngsters. Sexual abuse of children is arguably one of the most heinous of crimes for our society, and the state needs to take all steps necessary to stop these predators. While the 2,000-foot rule has received much attention, it is one component of a broader effort the legislature has taken in recent years to crack down on sexual predators. In 2005, lawmakers approved a sweeping package of initiatives to toughen Iowa's sex offender laws, including longer prison sentences and more supervision upon release. These measures were certainly a step in the right direction, but Republican senators believe more must be done. Republicans? Is this going to be a political issue? I didn't know that child protection was a political issue. Iowa needs a zero tolerance. Zero tolerance is a term which means you first must disconnect your brain from your speech and from your thought pattern. Zero tolerance means it doesn't make any difference what is reasonable. We have to meet a zero tolerance policy for sexual predators. This year, Republican senators are introducing a proposal that would require a mandatory 25-year prison sentence for an adult convicted of a first-time sexual offense against a child. You know where they got that first-time 25-year term? That comes from Reno Country in Florida, Dade County. That's where we go to find out how to write extremely poor legislation. Okay, the more predators we have behind bars for a longer period, the less we have to worry about where they live. I suppose that makes sense, doesn't it? It only costs you $70,000 a year to make sure you know where they live. In addition, I'm continuing to fight for legislation to reinstate a limited death penalty. I don't know what a limited death penalty is. Wouldn't you hate to be subjected to a full death penalty? They're talking about a limited death penalty.
Maybe the guy's going to come back to life.
Right. You step on his throat instead of shooting him, I suppose. Huh? So he wants a limited death penalty to those who kidnap, rape, and murder a child under 18. You see, one of the reasons why is that with all these tough laws, it would be far wiser to kill your primary witness, and so they're going to strengthen the penalty for that. Many opponents of these various initiatives argue that more efforts should be extended for counseling and treatment of sex offenders rather than punishing them with tough sentences or stiff regulations upon release. I believe, however, that to motivate reform and to better yet to prevent the offense in the first place, a strong, clearly understood punishment needs to be the law of the land. Due to Judge Cushman's action, Vermont parents are discomforted by a legal system that seems to care more for the well-being of sexual predators than the innocent victims who are destroyed. Iowa parents need to be assured that the state officials will put the safety of our children first. So says Senator Larry McKibben. Okay, Don, there's a couple of other people who have differing ideas about this sexual offender law that has to do with where the sexual offender lives. Oh, and before we do that, let me give you one hint here as to what I'm thinking about with respect to turning around this law. When we need to turn, looks like we've got a little bit of a sunshine problem here. Okay.
Shine some light on the situation.
Yeah, we
Literally.
yeah, isn't that something? That's not going to help a whole lot. Well,
We can still read it.
okay. We'll see what we can do here. Okay. We all want progress, but if you're on the wrong road, progress means doing an about turn and walking back to the right road. In that case, the man who turns back the soonest is the most progressive. So says C.S. Lewis. Don Burgmaier, will you give us some hints about other ideas about the 2,000-foot rule, Don?
Okay, John. I got an article here from the Des Moines Register, published January 23rd. Offender treatment can work, but instability hurts. This is written by Harold Williams. This is a special to the Register. This goes along the same line as what you were reading earlier, John, that somebody has sent in this article to be read or published by the Des Moines Register. His name is Harold Williams. Any man discharged from his prison sentence has served his term and should be allowed to re-enter society as any other felon does. I am a patient within Iowa's Civil Commitment Unit for Sexual Offenders. Have participated in treatment for the past decade and made these observations. First, the media have grossly distorted reports of sex offender recidivism rates. In reality, studies from Iowa indicate that over a 10-year period, fewer than 10% reoffend after going through treatment. You know, I've even heard comments up to 90%, but that comes from attorneys that probably, and others that want to build their case probably. I doubt if, I think it's probably closer to 10% that reoffend. I would guess that's far more accurate than the 90%. Because I'm sure that when you go to prison, you don't want to, a lot of people don't like to go back in. There are some people that like a roof over their head, so they may go back and do something again. But I think the majority of people want to stay out of the prison. Second, there has been an incessant push to educate children about stranger danger. The truth. The vast majority of offenses are perpetrated by someone known to the child or the child's family. Third, there is a myth that sex offenders cannot be treated. First, these men, willingly involved in the treatment process, behavior, and attitude to changes can take place that will lower the person's risk considerably. I want to make one comment. This article is coming from inside the prison. A man it has spent several years ago. So we are now getting a glimpse of the thoughts of the people inside the prison after they've been there a while. That is worth some consideration, I think. I'm not saying how much weight should go to that, but they have some inside knowledge that I believe is worth sharing. He goes on, insight is gained in treatment. A person learns to combat denial and to replace it with honesty. He learns to replace blame with ownership and personal accountability. He learns about the factors that combine in a person's life to create a sex offender, a drug addict, alcoholic, domestic abuser, or gambler. The offender has never learned appropriate coping responses, so he resorts to what has been modeled in his life. All this needs to be relearned through treatment. The major factors that have led us into our offensive behaviors are rejection, anger, fear, and feeling loss of power and control. The new laws and residency restrictions disabilize people when they deliberately need stability and acceptance. That serves to unravel the offender's ability to cope, making him angry at society, causing him to be rejected and alone at a time when support is critical to success. If an offender cannot live in town and has no vehicle or access to public transportation, he may be unable to travel for employment, therapy sessions, or parole officers' visits. This serves only to further alienate this human from love, stability, acceptance in society
I bet it's
in
stability.
general. Yes. That is not conducive to good mental health. No one wins, and no one is safer. Some caring souls ask what can be done to help. A win-win situation might be to gather listings from prospective landlords, employers, churches, and civic groups willing to reach out to released offenders. That's true. When an offender is released out into society, it has always been known that nobody wants to receive them back. And now we got this 2,000-foot law that makes it even worse for them. He goes on to say, maintain these lists at the sheriff's department in each county, where an offender can go to see who he is willing to rent to him, an employer, or to accept him into their group or church. I'll make a comment there. I believe there are a lot of churches that don't want to accept the offenders when they're released from society. There's a stigma that is put on them. Of course, to a certain extent, they may deserve it. I'm not saying they don't. But the church should welcome them really with open arms. How is the offender going to hurt the church? But people have that attitude that if the offender walks in the door, they're going to hurt the church. When in reality, the offender has, in the past, just went after an individual. They don't go in to offend large groups of people. So I think ministers are missing the boat at that point. Perhaps a trained person in the department could be available as a contact and support person. Treatment is a serious matter, and there is responsibility all around. The state has a responsibility to ensure adequate funding and space. Program administrators and treatment professionals have a responsibility to their clients. Clients have a tremendous responsibility to change their values, beliefs, attitudes, and behaviors. If all parties work together, there will be fewer future victims, and society will be a safer place. The answer is not an imaginary 2,000-foot barrier that evokes a feel-good response and nothing more. Harold Williams is convicted of second-degree sexual abuse in 1987. He resides in the Civil Commitment Unit for Sex Offenders in Cherokee, Iowa. John?
You know, the Iowa prosecutors, I don't agree with everything they do, but they have an opinion on this matter, simply because they do not see how in the world they will ever be able to do their jobs. And I think it's wise for them to let the legislators know that what they are passing is not proper in terms of enforcement. Of what value is it to protect a child by passing a law which cannot be enforced? that is almost worse than having no. In fact, it's counterproductive
So who
because
gets the benefit out of that, John?
I have no idea. The well, someone gets the benefit out of it because we're spending $12 million a year. In 4 years, we're spending $12 million a year in order to keep up this charade of zero tolerance, so that those assemblymen who vote for it can go back to their districts and say, "Look, I voted for this. I'm tough on crime. Put me back in that position." I'd say, "Sir or madam, you don't deserve a place in the General Assembly. You cannot handle such an important task as this." Well, here's what the prosecutors say. Iowa County attorneys, and this is from the Associated Press, January the 23rd, 2006, sex offender law doesn't work. The state's prosecutors urged lawmakers Monday to eliminate a requirement that convicted sex offenders live more than 2,000 feet from a school or daycare center. The Iowa County Attorneys Association said that the restriction makes it virtually impossible for offenders to find housing in virtually every city in the state and does little to protect children. By the way, there's some political subdivisions that are trying to enhance this statewide law, because they want bicycle paths and libraries and all kinds of things. In fact, in one community, not far from here, they want to even include parks that haven't been built yet on tracts of land that have not been yet purchased. So they're dreaming way ahead of time to make sure that no one gets a chance to live in that community. I'm not sure I'd want to live in a community where the city fathers have that kind of an attitude toward human beings, even human beings that they are disenchanted with. The group said the restriction does not provide protection that was originally intended, and that the cost of enforcing the requirement and unintended effects of families of offenders warrants replacing the restriction with more effective protective measures. The prosecutors asked lawmakers to take steps such as creating protected areas where offenders would only have a limited access, and to ban local governments from enacting their own tough residency requirements. That points up another problem. If there happens to be a daycare center near the church that an offender attends, could he go to church? How about if he had to have a medical, go see his doctor, get a medical appointment? Could he do it if it was across the street from the school? Okay, what if he would like to ride a bicycle? Would it be possible for him to ride a bicycle on the bike path if that was named as one of these things? Well, think it over, gentlemen of the General Assembly. And as one lady in the General Assembly said, wanted to correct me when I said gentlemen of the General Assembly. She wouldn't let me finish my thought and say gentlemen and ladies of the General Assembly. Well, the prosecutors have been asked to take steps such as creating those protected areas, and after the state put into place the residency ban, many local governments expanded it to include parks, libraries, and other places where children gather. Prosecutors said that the ban also makes it tougher to prosecute sex offenders because defendants are more leery of accepting a plea bargain. And the move comes as lawmakers began examining a tough new laws for sex offenders that they approved last year. We're going to have a debate on this issue, said House Speaker Chris Terrance of Sioux City, Republican of Sioux City. I don't see a groundswell of support for removing the 2,000-foot requirement. I do hear from a lot of parents who support the 2,000-foot rule. Oh, we're going to make it a popularity contest now. Since we've left reason, I guess popularity is about the only thing you can rely on anymore, isn't it? Critics such as the county attorney group have said it makes little sense to force sexual offenders to live a long way away from schools and daycare centers, but not restrict their access to those places. Research shows that there is no correlation between residency restrictions and reducing sex offenses against children or improving safety of children, the county attorney said. Rance conceded there are other steps that need to be taken. No one ever said this would be the end end all or be all, he said. Senate Democratic leader Michael Gronstal of Council Bluffs said virtually every legislator favored the restriction. Well, every General Assemblyman voted for it, 100%. We always expressed reservations about those restrictions, what those restrictions should be, but most of us supported the restrictions when they went through the Senate, Gronstal said. Even then, we said this wasn't a panacea.
You know, you know what they call that?
What's that?
A flip flop.
Flip flop. Yeah, you bet.
They are flip flopping all over the place.
Okay, you had some stories.
Oh yeah.
Okay.
I was waiting for the grand introduction. You didn't give me the grand introduction.
Here's the grand introduction.
Okay.
In order to learn on this program what we need to know about the judicial system, we need to call in a judicial expert, Terrance Walker.
There you go. That was the best introduction I've had to date, right there. Thanks a lot, John and Don, for having me on the show once again. I am the judge of the judges here in Iowa, and it is my intention to influence policy as it comes to the court system. I know John and Don do the court policy. I mean, they do the influencing as it pertains to DHS. I do it as pertains to the courts here in Iowa and across the United States. And I had a group called VJO, Vote Iowa Judges Out, because I do believe in the right to vote, and I do believe that we should all use our right to vote. And in one of the rights that we have to vote here in the state of Iowa, we do have the right to vote out judges, which has rarely been acted upon. I've undertaken this crusade the past several years to educate the public via cable access and otherwise online about the right that we have to do to vote out the judges here. I just had a couple of stories here real quick. Not a whole lot happening. They've had the Senate confirmation hearings of Judge Alito. I call him Elito because he went to all these elite universities, and he went to had these elite organizations he was a part of, such as the Owl Club, which there was a little bit of controversy in him mentioning that on the proceedings the past couple of weeks, because the Owl Club supposedly didn't want any black people at the prestigious college that he went to, or women for that matter, but he didn't recall joining. So either this guy lied about not being a member of this organization or not being able to recall it, or he lied about being a member, because no one seems to know how he got in the Owl Club, or nobody can recall him being in the Owl Club. So, but it's pretty much cut and dried, so I'm going to save time discussing the Elito nomination, because I think everything is pretty much decided that he's going to be on the Supreme Court. So not too much we can do about it as of now. But I will turn to a couple of other issues here. We did have another nominee for the federal bench in the news here recently. This was a January 22nd article on Salon.com. Judge James Payne, September, was nominated to join the 10th Circuit Court of Appeals.
Is this the correct one, Terrance?
Yes, that's the correct one. You're pretty good on that. He had been basically appointed chief judge in Oklahoma to the district court there, federal district court, and was pegged by President Bush to be on the 11th or 10th Circuit. Excuse me. Well, he's in the news as of late because he's apparently issued more than 100 orders in at least 20 cases that involve companies in which he or his wife own stock, which is a violation of a couple of different federal statutes, and it looks like the ethics uh, that he's supposed to be bound by. But according to Title 28, Section 455 of the United States Code, he is not supposed to. He's supposed to disqualify himself if he owns any stock whatsoever, even if it's just a fractional one share. He's not supposed to take the case. But anyway, in news more close to us, a couple of weeks ago, our Supreme Court Justice for the state of Iowa, Chief Judge Lavarado, I call him Liverado because he definitely talks out of both sides of his mouth, apparently issued the State of the Judiciary. We're one of the states here in the United States, few states, that has a State of the Judiciary lecture from our state Supreme Court Justice, the chief one. In it, he cites a number of things that he's apparently done, or he's responsible for, or that the judiciary here in the state of Iowa is doing. None of them that great, in my opinion, but I'll just go on to state he's talked about how he's tried to get the administration of justice more affordable and more accessible to all citizens, even the poor folks that can't afford a good lawyer to go and represent them. He's talked about how they have some unbundled forms, do-it-yourself kits, whatnot, so that you can represent yourself, which I think that that's an important right that not all courts recognize. And being a pro se litigant several times, I can tell you firsthand from my firsthand experience and from other pro se litigants' firsthand experience, there's a couple more guys that represent themselves in courts as well, that the courts tend to not be too friendly, user-friendly to people that represent themselves, no matter how much you know. You can be very knowledgeable and present your case very well, but you're not going to get your day in court regardless in a lot of instances. So to me, Judge Liverado, I think that, speech was good, sounded good anyway, but is this theory or is this practice we're talking about? Because I have not seen any changes in the way the courts have not been user-friendly to people that represent themselves. But anyway, and the main thing that I wanted to talk about that he did bring up, which is why we should really all call him Liverado, in my opinion, is that the Chief Justice said that the judges are accountable. Now, he went on to talk about, first off, that they had implemented some sort of code of professional conduct for prosecutors and have gotten more rigorous with the prosecutors. And then when it comes time to talk about the code of professional conduct or the accountability of the judiciary, he doesn't talk about how they've implemented any new measures to curb wayside judicial people. And one of the things that he lays out forth, and you can see this speech, it's printed up on the Iowa Supreme Court website. You can either Google that or you can go online and go to www.judicial.state.ia.us and you can look at the speech yourself. But one of the funny things he said, or I shouldn't say funny, one of the weirdest things he said is he quotes in one part of his speech, he puts judicial independence means fair and impartial courts. He also goes on to say,
I don't know where they come up with that. In my opinion, judicial independence means nobody bothers to look over my shoulder or to question my rulings once I make it.
Exactly. And one of the other weird things he says, independent courts are accountable courts. Now, when you think about this, think about other
what makes them
independent.
accountable?
Yeah, when you think about the word independent, how is that accountable to whom? You got to ask that. Independent. If you think of an independent person, that person is on their own. Now, I know several independent people. Uh, they didn't play by anybody's rules, but their own rules. So when you go and say that word independent and you're related to a court, and then you say that that court is accountable, accountable to whom? Is it accountable to the Chief Justice Lavarado? Or is it accountable to us, the people? Now, if we're supposed to be a government of the people, by the people, and for the people, then I cannot say in all honesty that I would agree with the statement that independent courts are accountable if we're talking about accountable to the people.
I think it goes back to that concept of the king can do no wrong, and I thought we fought a war over issues like that with our comrades across the pond because we didn't want to accept their legal notions. Accountable only to God was the idea of this business of independence and the way they thought about independence. See, they said we don't since the king is accountable to God, he needs nobody else to look over his shoulder. He doesn't need anybody to tell him how to rule and what his restraints are.
Yeah, and I think that we're fighting a brand new war because the judiciary is one of the institutions here in the United States which has basically went back to the ways of merry old England and implemented this the judges can do no wrong kind of policy and have basically enacted over 100 years ago the precedent of judicial immunity. I don't know how many people out here know what that means, but if you have something done to you wrong by a judge within a courtroom, no matter how heinous it is, malicious it is, they can even do it on purpose. Say, for instance, they just you're going into a court of law and you have a traffic violation, and for that traffic violation, the judge takes your kids. Now, I haven't seen a case like that yet, but I'm sure there's similar heinous things that have gone on in court. I would say that you could, in all likelihood, you would not be able to sue that judge, no matter how heinous or malicious that judge's actions are. If he's clothed in that robe and he does anything in that courtroom, makes a ruling or order concerning it, then you're basically not able to sue him for anything. You had a comment, Don, I'm sorry.
You were talking about the judge taking children. I read several years ago that the IRS has taken children, but I'm sure that what happened there, they turned them over to the DHS. IRS, as you know, is a collection agency, or they go after your money. And if you don't pay up, we'll take your children. That was the attitude at one point in time, about 10 years ago anyway.
Well, in Iowa City, not many years ago, a fellow had a traffic offense that he was stopped by police for. He was jailed, and because he had children in the car, the children went to foster care. They didn't bother to check with mother, who was at a choir practice at the church. So here you have somebody who was in charge of sending the father to jail, who could have straightened that whole thing out in a hurry, because the children didn't need to be separated from their father.
Yeah. And back to this judicial accountability issue, there has been little or no judges being removed from either the federal bench or the state bench here in Iowa. I'd say a handful. Impeachment proceedings have worked less than a handful of times since impeachment has been a proceeding for judges in the United States. I'm talking about the federal judges now. There's only been a handful of Iowa judges ever removed from the bench. And so for them to say that the independence produces accountable court and is producing a fair and adequate pool of judicial officers, I would say is laughable. You know, there wouldn't be such a big outpouring of disgruntled voicing of opinions on the judiciary the past couple of years, if the judiciary was actually seen in the light that it is trying to cast itself, which is that it is so independent, it was so fair, it is so righteous. It's just not the case. You get a judge with you get a college degree, law degree, and and if you're able to have a clean record and lie a little bit, it looks like, as it pertains to the Alito hearing, and cover your tracks, anybody that fits those characteristics can be a judge. So, in all fairness, I think that it's not producing. It doesn't have the checks and balances to produce the right kind of people for that role. But one other thing, the judiciary here in Iowa recently, in regards to this matter in Clay County, in regards to this, also to this, what Judge Laborato was talking about, his new prosecutorial board, which that they proposed to heighten the standards for prosecutors and to actually follow through on some of their alleged violations of their ethics. In December of this past year, Michael Zener of Clay County, who was a prosecutor, who was faulted for 168 fictitious cow lamp charges that were prosecuted by his office for 6 or 7 years. He represented both the people that were ticketed and the county attorney's office. Well, the judge that approved the alterations to the charges basically got promoted. And the prosecutor that did all this wrongdoing and malfeasance and willingly participated in this conduct without reporting it, which is an ethical violation, she got a promotion. And that's Magistrate Nancy Wittenberg, while the prosecutor got a public reprimand. And this took place in December. This is reported in December 17, 2005 Register, which leads me to the question: should we be able to sue a judge if they deliberately refuse to obey their oath of office, or does some sort of wrong to a person or to a party maliciously? I think the overwhelming answer is yes, and that's why I think that we should all sign the petition, which I have online there. It's this third page there. I think we should all sign the petition online to get our legislatures to promote the jail amendment, judicial accountability amendment, and that's at weblocation1.com/petition. Go to that website and sign the online petition and support this move to pass jail here in Iowa.